You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
Hello, I'm Cristina from CVG Solutions, and I am a data protection consultant. I deal with anything in connection with data protection, including data protection officer for primarily small and medium-sized organizations, including charities.
Hello, I'm Michael Mulholland. I'm a partner at Spencer West, and I specialise in data protection and AI law, and I offer DPO services.
So today we're going to talk about the case of Forsters versus Uddin, which is a really interesting case. Do you want to give us a bit of an overview of it, Michael?
Yeah, so this is around an application for an interim injunction for breach of confidence. So the background is Mr. Uddin was locked in a neighbour dispute over nuisance, over the sound of a barking dog, and rights of way. And Mr. Uddin would claim that he was being harassed by Forsters, particularly against two employees. So he made a DSAR asking for all data related to that with his harassment claim. So there would be video recordings or audio recordings, expert reports, and the like. So this is where
it goes wrong. These are gone wrong because what Forsters does, they then released over 3,300 documents to Mr. Uddin, which not only includes his data, but includes data of past clients as far back as 2009.
Yeah, it's the stuff of nightmares, really. So already neighbourhood disputes are highly charged, and the error that occurred was really unfortunate, and I pity anyone who'd be involved in a situation such as this. But it was a clear error. So, as you say, Cristina, there's 3,000 documents landed into the possession of Mr. Uddin by way of an unfortunate mistake. So apparently, Forsters used the services of a third-party company, KL Discovery, to discover the documents, and there was a search done under the name of Uddin. So that's where you would start in getting all the information around the data subject, Mr. Uddin. And unfortunately, this link where the entire database of all searches relating to Uddin were provided to Mr. Uddin. And as he rightly said, he wrote back the next day once he received the DSAR. So he made the DSAR on the 15th of July, 2025, and then it was released to him on the 18th of August, 2025. So again, that's sort of slightly out of time. It should have been delivered within 1 month. So again, that sort of indicates to me that potentially they're under pressure to deliver within time. So maybe, unfortunately, checks weren't made, and so we would have to ask how this error occurred. But it just seemed to be that there might have been a lack of human oversight, first of all. But what do you think, Cristina?
Yeah, so I don't think that, what happened is that, or what it appears is that, they've done the search, sort of revealed all of these documents, and then they're just simply forwarding them to the requester, to Mr. Uddin, without actually, checking them, redacting them, which is what you're supposed to do as part of data protection, to make sure that data that shouldn't be disclosed is not disclosed. So I think that's their first mistakes. They do realize that eventually, and so they do ask him to delete and return the data. But then Mr. Uddin sort of refuses. They say, you sent it to me, now I'm going to use it. And, Mr. Uddin seems to be quite eloquent in his sort of communication and sort of his legal proceeding and the legal proceeding. So there is some data in there which included, for example, instructions to the solicitors, like their own strategies. So he wants to use that in the case. And what I found really fascinating as I was reading it, it's the distinction between confidential data and privileged data, where, if something is confidential, it is up to the court or the court needs to do a balancing test between, releasing it, and how that is going to impact the public. While instead privileged, documents or data, that balancing test has already been done and it has been determined that is non-disclosable. So I thought that was quite interesting debate. So to me, it's from a data protection perspective, there is something that the judge says in the case that I don't particularly agree with, because what the judge says is that in his view it would be wrong and disproportionate to require the claimant, so in this case the Forsters, who is a controller, to examine all of the 3,300 documents individually, and basically, include them or remove them from the disclosure. But isn't that exactly what it is required by GDPR, and therefore, as a controller, that's your obligations. So not quite agreeing with the judge on that.
I think that request came from Mr. Uddin as well. It's a way of well, he once the documents came into his possession, he was sort of he retained some element of control.
Yes.
I mean, going back to how the error occurred there, because as you say, the third party company should have. Well, they claim that they carry out a full service, which, in terms of making the redactions, withholding the relevant documents, so it's like a cradle to grave delivery of the service. And then so once this is thing around when you outsource or data controller, processor, they're carrying out services on your behalf.
Yeah, but the controller still retain accountability and responsibility.
That's exactly. I was going to say you can't offload that. So Forsters it's in here in the judgment, sort of saying, well, actually, that is the third party's fault. But everyone's responsible down the chain. You've got to say, well, this is the work that's been delivered up to us. Yeah. That needs to be checked. So someone should have checked at the side of the discovery company. And then once it was received into Forsters, before you send it out, you've got to read what you're sending out. Yes. And check the links. So it was a complete nightmare. But again, it's sort of human error. So by mistake, that has ended up.
But hang on, I'm going to stop you there, Michael, because is it really human error, or is actually lack of appropriate processes and procedures? Because to me, that's what it sounds like. Do you see what I mean? Yeah. That Forsters does not have the correct steps, to actually check that the third party work has been done to quality and to expectation, to requirements. Because if they've done that, they would have spotted it straight away, and they could have sent it back to the third party to say, hang on, you need to review these as part of your services. You promised that you do these. So maybe I think that from what I gather is that there is a lack of appropriate process and procedures all the way through the chain. So I don't think it's a human error.
No, there's lack of technical and organisational procedures in place to manage the DSAR.
And also maybe a lack of awareness as well. Do you know what I mean?
Because and it might be that I'm just surmising here, but because I say it's slightly over the time period where they should have delivered the DSAR back. So maybe they felt under pressure to deliver it. And yeah, so this the Deputy High Court judge as well.
But couldn't have they asked for an extension, because they can extend it up to 3 months? So they could have done
they could have
that.
said it's a bit complicated. They could have bought a bit more time.
Yeah.
They could, again, so they're not utilising the tools that they had at the disposal. So act in haste, repent in leisure. So
Yeah.
and that's what's happened here. And then it's landed in the character of Mr. Uddin, which is he's a litigant in person.
Yeah.
But he's obviously done his homework. He was well researched, and he was even so the day after, once he received and he sent an email back to the to Forsters, he really clearly set out what had gone wrong. Said, I'm not entitled to this information. It relates to other people. It's nothing to do with my claim. You breach your obligations of the GDPR. You breach your client's privilege and breach of confidence. And so he knows what the score is, but
yeah. But as I said, he's very sort of aware of the various legal, legislations, and he's telling them. That was quite interesting.
Yeah, no, it's such a nightmare. It's something that you would really, if you wouldn't want to be in their shoes, you've got to.
But you see now what's happening, the other clients that are called Uddin as well, the Forsters have said in the past, they could now take legal actions against them. Do you know what I mean? And so the nightmare, it might not be over.
No, I know. And again, we wouldn't speculate how this happened, but it does show though that perhaps companies still, we've been doing data protection for a long time. They don't always pay the importance or the I don't know, to say respect, but in terms of data protection. So it's a really important subject. And then when things go wrong like this, and they go terribly wrong, it's not something that you can put on the back burner. I mean, you delivered DSARs for clients in the past, and what's your experience of it? I mean,
you need to have to make sure that the process it's streamlined and the effort is proportionate. You need to make sure that you have strong records management, strong systems. So make sure that you keep as much as you can centralized, so that it's easy to recover, it's easy to then put together. But you've got to go through the process of redacting it. You've got to make sure, because a search could reveal, all sorts of outcomes. Especially if you're, for example, you could do a search on the initial of the individual, and that could also potentially bring up someone else's who's got similar initials, for example, or words that have those kind of letters. So it's really, you've got to have a proper process and procedures to do this. And if you need to utilize the 3 months, extend it. But I wouldn't rush it in terms of, obviously you can't go over the 3 months. So, but use that time if you need to, because it's if you don't, it's going to come back and bite you, and it's going to cause all sorts of issues. And for me, it's the reputational damage of the organization. This is now, this case law is now, a public document. Personally, I wouldn't trust Forsters with my personal data. Do you see what I mean?
It's unfortunate for Forsters clients, because the legal opinion, the reports, they handed that over to Mr. Uddin, and this was the purpose of the interim judgment. So that's part of the purpose, because it was interim, because you have to act with urgency and to try and, if there's going to be any erosion of the confidentiality. You need to act quick, but it still took a couple of months for this to come to, for the application to be made and to be heard. But in favour of Mr. Uddin, he didn't compromise that he in terms of it wasn't disclosed to anybody else, so he preserved the confidentiality there. But he did try and use the data that came into his possession in order to pursue his own legal claim. Yeah. And so with witness statements that he produced, then that would be using some of that data. So that is putting it into the public environment then.
Yes. See, I wonder if he hadn't said that, you know, he would have been able to use it.
Yeah, and he did come back straight away. So what if he did? How would they have noticed as well if they'd delivered the DSAR and they thought they'd delivered the DSAR? Because in fact they hadn't delivered the DSAR at all. Yes, they just delivered a data doc from a discovery search. But even the time at the application, the DSAR was then held back because they thought, well, let's resolve all matters before we actually do the DSAR in this matter.
But the point is that he was no under any obligation to actually tell them, by the way, you know, you send me, you know, all of this data that is not relevant. He was under no obligation to tell them. So he could have, do you know what I mean? He could have stayed quiet and use the data that it was relevant to his case and just go on with it.
Yeah. There's some interesting bits though as well around the use of equity here, so that you want to put because there's been a clear error, so it's a common mistake. So you want to put the client back in the position they would have been but for the error, and so that was the outcome of this, because an order was granted, and so he would have to deliver up all Mr. Uddin, that is, would deliver up all the documents that he shouldn't have back in his possession, or destroy them. Yeah. And so it's quite interesting to go over the case law around where it's equitable to intervene. And so lessons learned. What are they? Read everything before you send it out, I guess, before you press that final email.
Yes, but also I would say, you know, hold your third parties accountable. You know, so you've got to have a way of scrutinizing the work that they do for you on your behalf. Yeah. And if it's not up to, you know, the deliverables, you know, that you've signed up for in the contract, send it back for rework. Really, to me, it's, you know, make sure that you understand your responsibilities under the data protection. Make sure you have, you know, the right processes to support you with that. Make sure your staff is aware and trained, because each of them will have a responsibility to it. So I think this is a really interesting case that actually goes to show that if you don't have any of that in place, how it can go wrong.
Yeah, I totally agree. So again, it's back to the basics. It's training, awareness, and just double checking before you send anything, and just reviewing the work, because you can't outsource responsibility. So if you're outsourcing something, you're essentially asking someone to help you in order to deliver your obligation, and you can't outsource that. You've got to have the oversight to make sure that these mistakes don't occur. So it's a lesson for all of us working in law firms and otherwise. It's a lesson for every controller. Yes,
it doesn't matter what kind of business you are. If you're a controller, this is a really good lesson to learn, and hopefully this will help you to be robust going forward. Well, thank you for listening, and we'll see you in our next case.
Okay, thank you very much. See you soon.
Cheers. Bye.